to stay within that length for the board to answer, which sometimes gets to be a long answer.
Sure.
And that goes back and forth between the dialogue and all too. And,
I
don't know what they have the right to be heard, but do they have the right to question it?
No. Most of these resolutions and ordinances specifically say it's not a question and answer session. You have a right to state a position to the board. I don't like it because of X. I think this is foolish because of X. A lot of counties will have a monitor where they've got a green light and a red light, and they time it for you.
Well, and we're getting there.
So, but
started research.
the best way to do it would be for a citizen to come up and voice their complaint and give them their time. And at the end of it, if the chairman feels like responding or giving additional time, if they're asked for additional time to make that decision then, I think the citizens should be able that the citizens should be able to state whatever their concern is and have the opportunity to state it without interruption if possible. But we've got the ability in the ordinance and resolutions to say this is not a question and answer session. We're not mandated to answer questions pursuant to the statute. In fact, I would usually say not to.
Well, in the complaints I have gotten, well, I've gotten complaints because they were limited to 3 minutes, but I've also gotten complaints that we have let people go on too long, of course, sometimes 50 minutes, and I've received complaints that way. I would like to have us have a clock, and have looked at some different ones where it shows their time and it's a countdown clock, and it's large enough that people can see it. But if you have to enter into them with dialogue, well, then it's a never-ending thing. Purely a statement. And then, of course, if we could still go like we're going now. We could have workshops without public input. And then have our agenda. And if we can ever get it to when we put everything on the workshop agenda and then just follows right on through to the board meeting agenda, they're given that morning,
Sure.
and then they can speak, and then before we actually hit our agenda items, that's the cleanest way.
I will say this, as a citizen, I can understand why you would want dialogue. As an attorney, I don't want dialogue. So as Jeff Goodman, the attorney, I would tell you, if it's a question and answer session, it's probably not going to be good for us. What I would do is say, you set a time that's a reasonable time, let them speak, let them get their comment out, voice their position, opposition, or they like it, whatever it is on an issue that's going to be voted on. The board has the right to take that information and process it so it understands the public sentiment before it votes. But I got to tell you, the general blanket rule, I don't think that there's any mandate for a dialogue. I think that there's a mandate that their issue or position get heard, their idea get heard.
Sure. Well, and just depending on what your topic might be, if you've got 50 people out there wanting to speak and talk about a budget, we need to limit them to 3 minutes. But if we've got 3 people out there wanting to talk about the budget, I don't have a problem giving them 5.
Well, and I would say this, whatever it is, Mr. Abbott, be consistent with it.
Sure.
Whatever it is,
Yeah.
be consistent with it. If it's 3 or 10, I don't care what it is, be consistent with it. Because what would bother me if I'm the citizen that got 4 and another citizen that got 14?
Sure.
Jeff, do you think that this would eliminate this, or be able to eliminate the sign-in sheet so that people would know in advance? If we agenda all of our items,
I like this.
and that's
I like the sign-in sheet because what I think we should do is have them. I think we should have the people that want to speak on the agenda items to sign in prior to the meeting.
Sure.
That would be passed to our chairman, Mr. Bush, and in the public hearing he calls them. X wants to speak on X topic that's on the agenda. Where it's going to get a little bit more dicey is if we bring up an issue that's not on the agenda. We've got to let the public comment on that before we take action on it.
So would you say probably the best thing we could do is to put the list out there and then call for the list after we open and do our invocation and everything, just prior to the agenda? That way they've had a chance to get here, just in case they only got here at 9. They have a few minutes to sign.
I'll let the board make the decision on when they want to take the list up. I mean, that's...
I guess my question was, not the sign-in sheet for the agenda items, the sign-in sheet where it's random things. Could the sign-in sheet include only the items that are being agenda for today?
We don't have to let people speak on an issue that's not going to be voted on or decided on.
Okay.
Now, we've done that.
Okay.
We've allowed people to do that. We're not mandated to do that. We've done that based on history and what the board feels like it should do. But the legal answer is we're not mandated to do it. If we're going to take action on it, or if it's a proposal that we're going to do something about, you got to remember this is a board meeting. That's why some things are scheduled as public hearings. Some things are scheduled as executive sessions. Some things are scheduled as what? That means something. It is a board meeting. It's the ability for the board to do business through your day-to-day manager. So really, I mean, if you come to a school board meeting, the superintendent's doing a lot of talking and his staff's doing a lot of talking and they're interacting with the board. Okay? The public gets to see you do business. And now when you vote on something, the public gets to speak on it. If you're going to take action, the public has a right now by statute to speak on it and say, I like it or I don't like it, here's why. And that's a good thing, I think. But you're not mandated to let somebody just randomly come up and say whatever they want to about whatever. So there is an openness that we've had, and now some openness is required by statute. But you've got the keys to give outside of what the statute's mandated. You can make it broader. You just can't make it more narrow.
Sure. What, just out of curiosity, what did the legislature do for themselves along this same line?
I don't have the ability to go to Tallahassee and get on the floor and start talking for 5 minutes about something that's before the
They
legislature.
didn't do anything in their arena. Hey, along those lines, I thought you had said something about limiting the overall public's time.
Yeah.
In other words, you wouldn't have to give 8 hours for public input.
Yeah. Subsection 4D says the board can give rules or policies that limit and specifically designates in 4D, designate a specified period of time for public comment. What you see a lot of counties do is they'll say, listen, we're going to have public comment for a 20 or 30 minute period. So you're not going to filibuster us by public comment today. You got 20 or 30 minutes, we'll go to the first and we'll go to the end. But after that period of time, we're going to something else on the agenda. So you've got the ability, the legislature says, to limit it. Now, I don't think you can come in and say we're going to do 3 minutes and then we're moving.
Right.
I think you got to give them time to let them speak,
Sure.
and then you can move on. But
What
I
if you
think
have more names than you've got to? If you've got 10 names at 3 minutes?
I think you got two options. You start at the top and you get to a point when you're done with the public time, or I think you say we're going to either extend the period today because of the names, or we're going to limit, instead of 5, we're going to give you 3 now because we're going to try to work everybody through and we're going to stick to it. But I think the board has got the ability to set the amount of time. My suggestion would be 20 or 30 minutes for public comment. And I've rarely seen it go much past that in our meetings.
I've seen 50 minutes on
Well,
the first.
I would like for everybody to be able to be heard if they've got a,
And that's fine.
and I don't.
You don't have to set a limit. You can
No.
say they can go on as long as they want to.
Well, I mean, I want a limit per person.
But total.
Yeah, I mean, I think everybody deserves to be heard, and
And I agree.
And I'm just telling you what your rights are as a board.
yeah, whether you like it or whether you
Yeah.
don't like it,
I
I want
agree.
to be able to.
I agree that everybody should be heard on an issue. I find it difficult when they bring issues that are not on the agenda and just blindside us. That's where I find it difficult. And then want us to make a decision on it.
I understand when they do it, and I usually understand why they're doing it. From an attorney of a board's perspective, we are naive to get into that.
Yes.
That's just not a good thing for us.
Right.
There's a reason there's an agenda. There's a reason you control the agenda. There's a reason there are certain things that by statute are required to have public hearings. I mean, we bring some of it on ourselves. I will tell you this, though. If we implement it, we got to follow it. The worst thing we can do is change it and do a resolution and then not follow it ourselves. So if we're going to do it, we got to follow it. Otherwise, we might as well keep it the way we are and try to comply with the statute.
Well, to add to Commissioner Gothard, if they come up here and bring something up that we're not talking about, there is a way possibly that we can look into it later on.
Sure. Yeah, there certainly is.
And tell us if you're serious about this, tell us about it later.
Sure. I will say this, and I I speak, when I take off citizen hat and I put on attorney hat, so I'm talking as an attorney here, not as a citizen, because I may be saying something else about the citizen. When somebody comes to you and says, I want X, or I want Xers on an X, there is no statutory mandate to, just because it's the board's meeting, it's the board's business. You were elected to conduct business, and he's here to help you, and I'm here to help you. But it's the board's business how you see fit to conduct it. And if 3 of you want it done, it needs to get done. But just because one says do it, I mean, really, it's the board. It's board's business. And I'm a big believer in that. I'm a big believer in, and there's a ton of things to get done in this county. And he's got more on his plate than he can do. And you have to figure out how to use his resources or help him use his resources wisely. You know, so I'm not telling you that it's not important, or the citizen's request is not important, or their concern is not important, because most of the time it is. But I'm telling you, there's no mandate to dictate, I'm going to do it, I'm going to do it now. There may be a political urgency to do it sometimes, but as far as a statutory mandate, it's not there. Okay. Well, that is Senate Bill 50, which is now Florida Statute 286-0114.
I think we need to,
I got a feeling we're working our way to minefield.
you know,
New laws and all.
I look at the purpose that this board has a county attorney mandated, and by all means, I'm so proud that it is. I would like to be able to task our attorney to bring us his recommendations. And not that we wouldn't have a little different of opinion, but bring back the man that's representing this board, bring back a recommendation to us for us to adopt the way that we conduct business. Now, even Robert's Rules of Order, you actually, if you're going to follow Robert's Rule of Order, my understanding of the law is you've got to adopt Robert's Rule of Order. And you need to be consistent with following Robert's Rule of Order. But to my knowledge, this board has never adopted Robert's Rules of Order, because there is other rules of order to conduct business. But I would like a recommendation back to the man that's taking care of this board and represents and guiding and directing on legal advice, to bring back a recommendation of what we need to do, and see if we all can't come to a conclusion, and let's vote on it, adopt it, and move forward.
If that's the consensus of the board, and I don't know if it is, what I would recommend doing is just setting it forth in a resolution. So this is how we're going to
That would be the
operate.
best thing. There's 67 counties in the same position we're in now.
They are.
And you probably, in your circle, have the opportunity to see a lot of what they're doing.
Sure.
And if you could just pick the best fit for Washington County, I'm not sure.
I will. I understand. We're different. I mean, it's a different deal.
It is different, and if you, what you see is the best fit, just bring it forward, and, maybe with some options or different things, and we'll put it forth as a resolution. But I'm totally, committed to trying to get these meetings to where they're not, to where they are more organized. And I think we have done that. I think the commissioners recognize that we don't need to just ambush each other with motions right at the end in the commissioners section, which we have taken off. We don't have the commissioners section anymore. And the sole purpose of that was to get rid of these. One commissioner brings something up at the end of the meeting that nobody had thought about, heard about, and all of a sudden it passed. So I think the board as a whole is committed to trying to make this more professional. And this particular law may push us a little stronger in that way. And plus,